in my opinion, the judicial class are those who actually believe that the judiciary has some special authority and special power to decide fundamental cultural questions, and who are prepared on that basis to remove those questions from the democratic process because they know better. And if you think this is not the case, go to law school for about 10 minutes. Go to law school in Washington, D.C. for 10 minutes. There is the view by many that, and this is the H.L.A. Hart, the concept of law. I mean, this is nothing new. I mean, if you're a brother's boy like me, Voltaire's response to legality, the people can't rule themselves. They need to be guided. I mean, this is not a new issue. With respect to the academic elite, I think it are people who have severed themselves from any notion of the search for truth, and any notion that the truth is a gift to approach in awesome wonder, and who think that they create the world. I mean, the notion that somebody can get up and say, other things that Ms. Cott testified to, and that the view of marriage changed in the United States because of our reaction to the affair of Bill Clinton. Oh, okay. And you know that because how? Because it. Well, that may very well be. I mean, but I mean, it just, and let's assume for a moment, I mean, so you're a historian. Is history a way of knowing the truth? And if so, how would it be? And what's historical judgment? And have you ever known any historical judgments ever to be wrong? And what makes you think that yours aren't wrong? And what makes you think that you have anything to say about this, other than our mothers? I would trust my mother before I would trust Ms. Cott. Now, Bill Buckley had a statement that he would rather be ruled by the first 1,000 people in the Boston phone book, 100. First 100 people in the Boston phone book than the entire Harvard faculty. And now, I don't, maybe, no, I'm sure that people who go online and see this video will think, where's his pitchfork, you know? I just think that it's democracy. I really do. And you're going to make mistakes either way. You're going to make mistakes either way. I want to just talk about the federal case again, because I think there's two cases that are used quite a bit as kind of intellectual battering rams in this by people who support same-sex marriage. And that's the Perez case here in California and Loving versus Virginia, which is the federal case that held that it was unconstitutional as a violation of equal protection for states to ban interracial marriage. Let me just begin by saying this. The problem with interracial marriage was, well, there is interracial marriage. No one ever disputed that a black man could marry a white woman could marry an Asian. No one ever disputed that. The problem was that it was occurring. And what happens when people get married? Kids. And they would be, oh my God, interracial kids. And we can't have that. That's what was wrong. As a matter of fact, in Loving versus Virginia, that statute was part of the Racial Purity Acts of Virginia. Now, for your dancing pleasure and amusement, Mr. and Mrs. Loving were not convicted of getting married. Mr. and Mrs. Loving got married in the District of Columbia and moved to Virginia. Their marriage was lawful, even in the eyes of the state of Virginia. However, it was unlawful for an interracial couple to cohabit as husband and wife. And that's what they were convicted of. Now why? What would be their concern about people cohabitating as husband and wife? Once again, children. In reality, putting aside the issue of, well, the issue of artificial insemination and assisted these people would have absolutely no concerns whatsoever about homosexual marriages. It wouldn't be their concern because there'd be no children. Again, the problem wasn't, well, there was no marriage between blacks and whites before, you know. No, that was the problem. The problem was there was marriage between blacks and whites, and they wanted to stop it. So I mean, it's just you know, a rhetorical it's a rhetorical device, and it goes back to the question of how you see the human person. I'll end with this. If you see the human person as kind of a monad, a point that has there's no connection between the body and the metaphysics and the morals of the person. We're not a unity of body and soul and metaphysics, right? If you look at him just kind of as a material being with certain preferences that the law should allow you to the extent possible, you know, pursue, then you can look at Loving versus Virginia and say, well, obviously what this is just, you know, these were people who, this is perfectly apt to apply to same-sex couples. There is no difference between gender and race. Why? Because it's just another difference in people. So that's really what's at stake, finally. And John Paul II said in Ex Corde Ecclesia, what's at stake is the very meaning of the human person. That is the truth even outside the academic realm, and it's certainly the truth in this realm. So, yes.
You know, Father Spitzer has a beautiful book, Healing the Culture,
Yeah.
in which he points out...
Basketball?
No. Healing the Culture by Father Spitzer.
Okay, Father Spitzer was the president of Gonzaga, and therefore basketball was a joke.
Okay, but the point is he points out that before you can collect and gather people to a convention, to create a constitution, you have to all accept a certain set of rules.
Yes.
And those rules is every person who comes to that assembly to frame that constitution has certain inalienable rights. They're not given by anyone, they're given by God.
Right.
And those rights are hierarchical in nature.
Correct.
Okay? So first the right to life, then the right to personal liberty, and finally the right to property or to so-called happiness. Those are the principles which allowed and empowered the people who created this nation to create constitutional law.
Yeah.
And the Supreme Court, both in the case of the case you cited where a white man's property rights takes precedence over a black man's liberty rights.
No, that is the Dred Scott case. Plessy versus Ferguson said separate but equal was okay under the 14th Amendment.
So then the Dred Scott, it's a perversion of those principles.
Correct.
And once you abandon principle and reason, you destroy the civic community.
Correct.
And the only thing you're left with is war, civil war. With Roe v. Wade, the same perversion of rights occurred. The Supreme Court entered into God's arena. No institution of the state has the right to enter into that arena. I think that if all the Catholics in America, all lawyers, had that understanding, we can begin to heal this culture. Otherwise, I mean, look, most educated women today believe that Roe v. Wade is an empowerment.
Yep.
And yet it's an example of judicial tyranny.
Yep.
From a principle standpoint. But with education, with media, you can convince people that tyranny is a right.
Well, yes.
And so it doesn't surprise me that eventually this New World Order will also, it's just a matter of how they repackage things.
But it's here. I mean, unfortunately, in California, the basic principles that deny, not only deny, but make it civically unacceptable to assert that marriage and the self-giving between a husband and wife is the first vital cell of society. That is considered to be against the law in this state.